Hello to everyone, and thanks for joining Keating Chambers live webinar. I'm Holly Gavahan, Business Development Director at Keating, and I'd like to introduce today's speaker, Tom Lazar. Over the next 45 minutes, Tom will be sharing the background to the remarkable case of Castle Trustee Ltd against Bombay Palace Restaurant. Although largely a war story about a final account claim, there are lessons to be learned about the management and presentation of witnesses and expert evidence, the court's approach when things go wrong, and how we can all try to make the most of a bad situation, which seems appropriate for the current circumstances we find ourselves in, watching and presenting from studies, spare bedrooms, the kitchen, or wherever we can find an appropriate background. Tom has gone for a bookshelf and a bike today. Tom was called to the bar in 2005 after starting out in investment banking and strategy consultancy. The directories say he is a pleasure to deal with, even in the most highly pressurised circumstances. His practice includes construction, engineering, energy, shipbuilding and curry houses. I'll hand you over to Tom.
Thank you very much for that introduction, Holly, and welcome to my home in Sevenoaks. Yes, you can see behind me, I think, my bike, my gym, my pain cave, as I like to call it, which has become more of a pain cave since homeschooling 3 children. But let me tell you about the curry house. In 2018, I had the best practice at the construction bar. I represented a famous brewery in London, a cannabis farm and processing facility in Kent, and the Bombay Palace, the greatest curry house in all of London. Sadly, my clerks failed to negotiate a bartering agreement with any of these clients. I still give them grief over that. But this is the story of the curry house. But this was no ordinary curry house. This was a curry house frequented by prime ministers and presidents. Even Keating Chambers attended en masse to sample its delights. Despite winning the case, I can confirm that we were given absolutely no discount whatsoever. So why did they need our services? Well, this was a fairly typical final account dispute with arguments about variations and delays. What was remarkable about it was the state of the evidence from both parties and the approach taken by the parties in the conduct of the litigation. And what was interesting from a learning perspective was how the court approached and resolved this mess. So let me give you the background. The restaurant was on the ground floor of a multi-storey apartment block. The claimant developer had purchased all of the flats above the restaurant and wanted to transform them into modern 21st century living spaces for the sorts of people who live around Hyde Park. But in order to upgrade the flats, the developer needed to upgrade all of the services that ran from the apartments above through the restaurant into the basement below. A deal had to be done to grant a license for that work and to allow the restaurant to be closed while the work was ongoing. My clients, it turns out, are mean negotiators who drive a very hard bargain. The developer agreed a one-off payment of £100,000 for the closure of the restaurant and a further payment of £40,000 for every week the restaurant was closed because of the development. Also, they agreed to pay for the complete refurbishment of the restaurant according to the most vague and unhelpful specifications in the history of construction contracts. Inevitably, there was a dispute over 52 items of additional work and the 18.5 weeks that the restaurant had to be closed while the development was carried out. Now, I wanted to give you some insight into the sorts of upgrades that we're talking about here. On the top left, you can see the picture of the dining area before. Bill and Hilary, Tony and Cherie must have loved the ambience as they shared poppadoms and a Cobra beer. There's my doorbell. On the bottom left, you can see the transformation. Upholstered walls, banquette seating, circular ceiling coffers with elaborate dangly bits, all within the spirit of the compromise, we said. You're taking the Michael, they said. But what about on the right? Here we've moved from a perfectly respectable New York style fixed awning over the entrance and shading over a neat patio area. But this has transformed to a stone-clad grand entrance with engravings and feature lighting, retractable awnings with integrated heating to the delight of our patrons. All in the spirit of the compromise, we said. But the issues in this case were very straightforward. Were additional works instructed and how should they be valued? And was the restaurant closed because of the development or the additional restaurant works? Now, for such a straightforward claim, it had a far from straightforward route to trial. First, there was an adjudication, which ended up in a classic carve-up. The claimant got 50% of the variation claims, but lost on closure compensation on the basis of the scaffolding up for the apartments. The apartment refurbishments above was blocking the entrance, so the restaurant couldn't open until it was removed. Now, the claimant issued proceedings, and everything was properly pleaded. I would say that, wouldn't I? But then everything went quiet. It turned out that my client had let his business go dormant and didn't comply with any of the directions to serve witness or expert evidence. Now, for reasons that are still entirely unclear to me, like a phoenix from the ashes, the owners suddenly took an interest and wanted to fight the claim again. So along we trudged to ask Mr. Justice Coulson, as he then was, for permission to do what he had already asked us to do many months earlier. The judge was not impressed. But again, for reasons that are entirely unclear to me, the judge relented and gave both parties less than 2 weeks to file all of their witness and expert evidence. As no doubt the judge was aware, we were in trouble. When you take into account the time the client then took to decide whether it wanted to submit evidence after all, we barely had a couple of days to do what we could. What we hadn't appreciated was that the claimant was in exactly the same mess. It had assumed that my client wasn't going to do anything and hadn't lifted a finger to prepare its case either. In any event, we served something, but in the lead up to the 4-day trial that was listed, it became clear that none of the 52 items could be compromised and there was no way an effective trial could go ahead. However, the claimant disagreed, and Adrian Williamson, who led me, and I made an application to adjourn before Mrs. Justice Jefford. The judge was not impressed, but our application was successful. We were given our adjournment and relisted for a 2-week trial. So what evidence of fact did we collectively manage to conjure up? Well, the claimant had Mr. Harris. Now, he had decided to cover only 8 of the 52 variations, even though all of them were disputed both on liability and quantum. The view had apparently been taken that all of the work of proving the case could be left to the quantum expert. More on that later. As for us, we had dear Mr. Brown. Mr. Brown did cover all of the variations with a single paragraph each. Each paragraph read something along the lines of, "Oh yes, that one, yes, that was definitely part of the agreement and not extra work." So what on earth could the judge do with this? The poor Mrs. Justice Jefford, who must have found the whole thing a complete and utter nightmare. Well, this is what she had to say. Each party criticised the other for failing to adduce relevant evidence from material or potentially material witnesses, and lack of proof of Liberty's case was a primary theme of BP submissions. Yes, it was. I shall deal with those submissions on an item-by-item basis. It is plainly open to me to have regard to the contemporaneous documentation as part of the relevant evidence, but I bear in mind that I am doing so without the benefit, in many instances, of the evidence of those responsible for the documents. Pausing there, the judge was saying that a lack of witness evidence was not necessarily terminal to the case, as any shortfall might be made up by documentary evidence, but she was going to have to approach that evidence with caution, because in many cases she did not have the benefit of a witness explaining both the context and content of those documents. Well, what about the quality of the evidence? In any event, neither Mr. Harris nor Mr. Brown was a satisfactory witness. They were, of course, giving evidence about events that happened 6 or more years earlier, and in some instances going back nearly a decade. Both may have been tempted to reconstruct what had happened, putting the best gloss on the documents available to them. But in my view, they both went far further than that. They were both too inclined to act as advocates, not witnesses, and purport to give evidence about what others had said or done or meant, which they were not in a position to give evidence about. On occasion, they showed themselves unwilling or unable to give a simple answer to a straightforward question. I approached their evidence with suitable caution. Now, here is another important lesson. Your witnesses are not advocates. They are not put into bat for your side. They are there to give a first-hand account of material events. So what was the outcome? Well, the judge effectively threw all of our evidence in the bin. At least we still had expert evidence to fall back on. So what about programming evidence? Well, we had not provided any programming evidence. I'd like to say that we didn't do that because we had judged that this was a case that was not appropriate for expert evidence, and that was partly true, but time was also quite a material factor. The claimant did provide an expert report from Mr. Bordoli, the poor Mr. Bordoli. But it turned out that Mr. Bordoli had only been instructed at the very last minute because the expert who gave evidence in the adjudication, Mr. Burley, was unavailable. He described his approach like this. I have considered Mr. Burley's report, the document he has referred to, the methodology he has adopted, and the conclusions he has reached. I agree with Mr. Burley's approach and have independently reached the same conclusions in respect of the causes of delay to the building programmes and the extent of such delays. Severe limitations of time, perhaps so severe the typos couldn't be corrected, the requirement for me to submit my report by Friday the 23rd of June, and as a proportionate response, I have adopted the findings of Mr. Burley. He then cut and pasted the entirety of Mr. Burley's report verbatim into his own report. Now, I have never seen anything like that before, and the judge questioned the approach. It is right that the court should adopt a healthy scepticism in a case such as this, where one programming expert adopts wholesale the views of another, where it is done as Mr. Bordoli expressly stated it had been because of pressure of time, so absolutely no question of dishonesty here. It must call into question the extent of the expert's investigations and the care taken in forming his opinions. The judge went on. In fact, in this case, it seemed to me that Mr. Bordoli had formed no independent view at all. I am frankly at a loss to explain on what basis he could possibly have formed such a view. Quite extraordinarily, Mr. Bordoli had not even seen and had apparently not thought it relevant to see the parties' pleaded cases or any disclosure. He had therefore paid scant regard to Bombay Palace's case. Indeed, he did not have Bombay Palace's pleaded case or evidence before him. He had, however, been provided with, and to some extent relied upon, Liberty's witness statements in the adjudication, or at least Mr. Burley had, even though no statements from these witnesses had been served in the litigation, and their evidence was not before me. I fail to see how, in those circumstances, Mr. Bordoli can have thought that he was providing the court with an independent view. I placed no reliance on Mr. Bordoli's evidence as such. It was not expert evidence. It did not comply with the court's order. Mr. Bordoli had not acted in accordance with Part 35 of the CPR, and it could patently not stand as factual evidence. So, now the expert programming evidence is in the bin, along with our witness evidence. But what is the court looking for from expert programmers? Well, the judge gave very good guidance on that subject in her judgment. But a little bit of background first is that Mr. Justice Coulson, in the first CMC in this case, made it clear that he did not think that this was a suitable case for expert programming evidence. He may have reached that conclusion because the only programme in the case that reflected the restaurant works was a single bar on a programme that spanned 4 weeks. Anyway, this is what Mrs. Justice Jefford had to say. The directions had explicitly limited such evidence to evidence that truly involved the exercise of expertise in programming. On one view, the cause of delay is entirely a matter of fact, but expert evidence may be admissible and may assist the court in a number of ways. For example, there may be a complex programme for the works produced using programming software. There may be issues as to the validity of a baseline programme, which involves expertise either in programming as such or in the construction process. Assessment of the impact of a factual event on the programme may involve running or manipulating or adjusting the programme, which itself involves an expertise, not to mention software, which the court does not possess. The programme may have been adjusted on numerous occasions over the course of a lengthy project, and that itself may be the subject of expert opinion. The programme and impacts of events on the programme may involve the analysis of logic links and dependencies, which again may involve expertise in programming and or the construction process. The present case is not one that involves a particularly complex construction process or sequence. There was no computer-generated programmes for the works to be manipulated, and so far as I'm aware, no programmers at work on the project. I infer that the previous judge regarded this case as one in which there were unlikely to be any particularly complex programming issues, and any issues relating to delay were likely to be questions of fact, a view with which I wholeheartedly agree. In any event, Bombay Palace did not adduce any such evidence. A tactical masterstroke, I'm sure you'll all agree, which I would obviously like to take full credit for. So, no witness evidence or programming evidence. What about the quantum evidence? Was it here to save the day? Unfortunately not. Here the parties took slightly different approaches. First up, the claimant's expert, Ms. Allen. Now, I don't want to be unkind to Ms. Allen. She was the only person in the whole of the case who tried to get to grips with the issues. Without her work, the case would have been an utter farce. Even more of an utter farce, perhaps. Again, and apologies for reading out large sections of the judgment, but I think it's very important to see the approach of the TCC when it comes to reviewing evidence of this sort. This is what the judge had to say. On quantum, Liberty relied on the evidence of Ms. Allen. I have no doubt that Miss Allen was an independent and honest witness doing her best to assist the court. She was open and helpful in giving her oral evidence. She really was very good. And I make it clear, in many respects, she was an impressive witness, and I have no personal criticisms of her. She had, however, served a report which extended to approximately 8 lever arch files of material. The reason her report was so lengthy was that on the Scotch schedule items, she had set out what was, in effect, a narrative addressing 1, the basis on which the works were said to be additional, 2, what works were said to be additional, and 3, what works fell within the scope of the agreement, as well as the valuation of 2 and 3. Bombay Palace understandably expressed concern that Miss Allen was attempting to give factual evidence. Although in due course, Mr. Williamson QC recognised that what Ms. Allen may have been seeking to do was to work through her own understanding of the items. Having said that, in the joint statement of the reports, Ms. Allen recorded that she had been asked to provide a view as to whether items were considered as variations or not. Was in there. She was actually instructed to provide a judgment. In any event, Ms. Allen's report could not be evidence of fact, although it may have provided assistance to both parties and the court in identifying relevant documents. It certainly was. Now, just in case the force of that section is not immediately apparent, it is not a quantum expert's job to give an opinion on liability. If an expert does that, their conclusions will be disregarded and their evidence on matters falling within their expertise will be treated with caution. Well, what about my expert report? The wonderful Dr. Champion. In contrast to Ms. Allen, who I believe was giving evidence in the TCC for the first time, Dr. Champion is a seasoned campaigner. He did not fall into the trap of going beyond his instructions and was very clear about the limited nature of the work he was able to produce in the one day he was given to prepare it. Unfortunately, what he produced was only a few pages of ultimately useless material. Here is what the judge had to say. Dr. Champion recited his instructions as being to assess the value of the claim variations on a figures as figures basis. His reports said that he adopted the following approach. In order to assess the value, if any, of the I can't do his accent, I'm just going to do a deep sort of expert-like voice. In order to assess the value, if any, of a change, it is necessary to understand A, what is the contractor was originally obliged to carry out under the agreement, B, the work that was in fact carried out, C, how or why the change arose, D, any matters agreed between the parties as to the basis upon which the original work or changes were to be carried out. Hence, ordinarily, it would not be sufficient to identify an additional amount incurred. All of that is plainly right and makes it clear that Dr. Champion fully understood the issues that arose and the significance or otherwise of identifying additional amount incurred. I have no doubt that in doing this, Dr. Champion was trying to do his best in what were challenging circumstances not of his making. However, it had the result that what was before the court was a report that dealt at a very high level with the quantum issues, did not set out clearly or at all the basis for Dr. Champion's assessments, and which cannot fully have taken into account all the available evidence, including the documentary evidence. I attach very little weight to it. So, no witness evidence, no delay evidence, very little, if any, quantum evidence. What on earth does the court do in those circumstances? Well, a traditional view would be that the whole of the claimant's case should fail. After all, one of the first things a lawyer always learns is that the claimant bears the burden of proof. But one of the many things that struck me about this case was the length that a TCC judge was willing to go to in order to reach a fair and just outcome. Not that the judge was very happy about it. Here is what she had to say. Scott's schedule cases in which the parties and the court work their way item by item through claims or defects or whatever they may be are comparatively rare in the technology and construction court, despite the origins and name of Scott's schedule lying in what was formerly official referee's business. In such cases can be inordinately time-consuming, and the court, with the assistance of the parties, will always try to find ways to focus the arguments and reduce the scope of the issues. Unfortunately, in this case, by the time the matter came to trial, virtually every item of 52 numbered items was still largely an issue, and it is necessary in this judgment to address each item separately. So the judge consigned herself to the hard labour required to resolve each claim. But in this, there's a hint. The court expects the parties to assist the court to reduce the number of items in dispute. As I'll come on to later, the judge is likely to appreciate any efforts made to narrow the issues. As an aside, there was also a useful bit of law here, summarising the position on variations and additional work, where there's not a variation clause in the contract. I'd pleaded a very meritorious argument that there was no liability to pay for additional work under the terms of this agreement, even when we'd asked for it. And this is what the judge thought about that. Where one party requests another to carry out additional work, the expectation is that some reasonable sum will be paid for that work. There was no variations provision in the agreement, but that did not mean that it was not in the contemplation of the parties that there would be any additional works which were not within the scope of the agreement. If such work was requested by BP, then Liberty was entitled to be paid for it, either pursuant to an implied term of the agreement or pursuant to an entitlement that arose outside the agreement on a quantum merit basis. So there you have it. So the court went through each of the claims. And here's the next lesson that can be taken from the judgment. There are a whole number of claims where the judge, despite her best efforts, could not work out what it was about or what the quantum of the claim was. Where that was the case, she couldn't award anything. The water storage claim. Experts in this one had even agreed on the quantum, but in cross-examination it became clear that neither of them had any basis to do that. The claim was rejected. The ceiling coffers. This was the feature lighting I showed you earlier with the dangly bits. Even though this was probably the most obvious of claims in terms of entitlement, they didn't provide any evidence of the work done and the claim was rejected. In some cases, counsel for the claimant, in the absence of any evidence to prove its case, tried courageously to prove its case in the cross-examination of our witnesses. And it was remarkable how far they were able to go with that. But in the end, it was not far enough, as in the case of the kitchen wall cladding. Now, it wasn't all doom and gloom for the claimant. In fact, they succeeded on a number of claims, but the claimant was held to be bound by its pleaded case. Where evidence emerged that indicated that there was a potential factual basis for a claim, albeit not the pleaded basis, the claim failed. That's another important lesson. You set out in your pleaded case the case that you intend to prove. It's no good turning up to trial trying to prove something different. That would be unfair on the defendant, who is preparing its case on the basis of the claim as pleaded. There was also an example where it was obvious that there was some liability, and it appeared to be possible with further work to identify an appropriate valuation for it. But the judge declined our offer to provide further evidence on the issue. It is the claimant's case to prove. You have to come ready to court to prove all of your case. In a case of this sort, the court will not allow its resources to be used up fixing holes that should have been plugged before trial. In contrast, the defendant was given a little more latitude. Now, we were working out what our case was as we were writing our opening, so there was a degree of development at that stage. And this was incredibly frustrating for us, realising that a good defence was available on the documents which had not been pleaded. But although the court did view shifts in our case with some suspicion, it wasn't terminal to the new case. Where we could clearly demonstrate on the documents that the basis of the claim was wrong, the court rightly rejected it. But here was another lesson. I spent hours on the blinking boiler claim. In my mind, I created a delicate series of submissions which conclusively demonstrated that my client did not ask for this work and shouldn't have to pay for it. Ultimately, I couldn't present that in a way that the judge could understand or follow, and we lost the item. That's the lesson. If you have a very limited amount of time in the trial to explain your case, you can't, and if you can't do it clearly and succinctly, the judge is not going to spend the time and effort needed just to understand what it is you're trying to say. That is a lesson for everyone in every field. Don't be fooled by smoke and mirrors. Valid claims are easily explained and understood, no matter how complex the underlying issues. Speaking of smoke and mirrors, what about the delay claim? Well, having found that a little under half of the claims were variations, the judge was left with nothing to work out how that should be factored in terms of time. As she put it, there's no evidence or analysis which would allow me to disentangle the alleged effects of those items that I've found to be additional works and those I have not. At a very high level, it might well be open for me to conclude that the carrying out of additional works must have caused the restaurant to be closed for longer than was originally anticipated, but the evidence offers me no assistance in identifying when and for what period. Faced with these difficulties, Liberty, who was the claimant, sought to piece together a factual case as to the causes of delay in its closing submissions. This amounted, in my view, to a new case, and one which was very much a matter of impression. It provided no sensible basis on which I could determine what might have caused delay in the completion of the restaurant works, still less what had caused the restaurant to be closed. So, this was the result. After 2 years of litigation, the claimant had spent all that time and money doing worse than it did in the adjudication. Sadly, given all of the circumstances of the case, which I won't bore you with, I'm afraid this is a case where the only real winners were the lawyers. Well, what is the takeaway from this? The court is going to do the best it can with the information it has. If you are the claimant, you have to make the running. You won't be put under some unrealistic burden or standard of proof, but you must be able to properly articulate and evidence every aspect of your claims. Ultimately, there's less that the claimant's advocates can do to improve the position at trial. The claimant in this case had the chairwoman of the bar at the time as its leader, and even that didn't help. No matter which side you are on, confusion defeats good claims. You must find a way to explain your case clearly and succinctly. If the tribunal cannot understand the basic elements of your claim or defence, you will lose. You do have more latitude as a defendant, but developing your case at trial is a real risk. Ultimately, there should be no excuse in a final account claim like this. You should have all of your ducks in a row at the pleading stage, with only minor adjustments needed to witness and expert evidence arising from the other side's pleaded case and disclosure. There ought to be no excuse for getting into the sort of mess we did in this case. But before I end, I wanted to give you some insight into how, as an advocate, I apply basic tests to the witness and expert evidence that I have to evaluate for each case. It's not rocket science, and there are cheat sheets to help. One of the best moments I had at school was during revision for my A-level maths exam. I realised that they gave us a formula book in the exam. If you understood how to read that formula book, you had the tools in the exam to answer all the questions that were asked. The same sorts of things are available to us as construction practitioners. For witness evidence, it comes in the form of the TCC Guide, Section 12. The TCC Guide, incidentally, is the ultimate formula book for our work, and I'm regularly surprised how few people actually refer to it. This is what it has to say about witness evidence. A witness statement is prepared with the assistance of lawyers, but should set out an individual's recollection in their own words. Witnesses are expected to clearly identify facts that are in their own knowledge and those which are information or belief from other sources. A witness should present facts. A witness should not argue the case. A witness should not make extensive reference to contemporaneous documents. Witnesses should provide explanations on relevant issues that may not be clear from the documents. All witnesses must confirm that the facts stated in their statement are true to the best of their knowledge and belief. So if you have to prepare cross-examination, there is nothing better to start with than making sure the statement you're dealing with passes these basic tests. But what about expert evidence? Well, there's a cheat sheet for that too. Mr. Bordoli's cross-examination in this case, which was one of the most effective cross-examinations I have ever seen in my 15 years, simply adopted this guide as the framework, and the result was devastating. The Civil Justice Council's Guide for the Instruction of Experts in Civil Claims. When they are instructed to give or prepare evidence for civil proceedings, they have an overriding duty to help the court on matters within their expertise. Experts should be aware of the overriding objective that courts deal with cases justly, and they are under an obligation to assist the court in this respect. Experts, this is crucial, must provide opinions that are independent, regardless of the pressures of litigation. So even if you don't have enough time, that doesn't matter. You must still provide an independent opinion. Experts should confine their opinions to matters which lie within their expertise. Experts should take into account all material facts before them. They should indicate if an opinion is provisional or qualified, or whether they consider that further information is required, or if, for any other reason, they are not satisfied that an opinion can be expressed finally and without qualification. Experts should inform those instructing them without delay of any change in their opinions on any material matter. This, experts, is your get out of jail free card. This should be the touchstone that you use when preparing your case, because it's the touchstone that I use and others like me use when we are testing your evidence for the purposes of cross-examination. But what about the smoke and mirrors we often see in delay and disruption claims? Well, yes, there's a cheat sheet for that too. The Delay and Disruption Protocol from the SCL is a magnificent document. I hear people criticising it all the time, but I am unable to find any fault with it. Every time I'm told of a new approach to delay analysis, I make sure that I understand where in this grid the analysis sits. If a new basis of a disruption claim arises, I want to know why it's not one of the methods already addressed in this document. Now, these cheat sheets are the culmination of years of work by practitioners with decades of experience. You should never try to reinvent the wheel. The resources to produce an outstanding claim are freely available to you. Now, the last lesson is one about conduct. I have absolutely no criticism of the other side and the way that they managed this case, but they were clearly constrained by what I perceived to be a very difficult client. They would not accept a very sound adjudicator's award. They didn't listen and react to the court's directions, such as the direction not to provide programming evidence. They took an unreasonable position on the adjournment, insisting on a 4-day trial when that would have put the judge in an impossible position. Finally, when we offered on an open basis to deal with the bottom 50% of the claims on value on an apportionment basis based on the outcome of the top 50% of the claims, they rejected that approach, leaving the judge with all 52 items to address in her judgment. Ultimately, had they taken that deal, they would have been £2,000 better off. Judges are human beings. Although they are obviously very professional, it is always easier to find against someone you dislike and in favour of those you like. Make the judge's life easy, and you might find that you gain some advantage in the final judgment. I hope you found that useful. Thank you very much for your time.